Hey, this is a follow-up to a two-part video series I did back in late May entitled Abolish Religious Exemptions from the Law. In that series, I talked about a case that was to be decided by the United States Supreme Court, Christian Legal Society v. Martinez. Well, I'm happy to report that on Monday of this week, the last day of the court's 2009-2010 term, the decision in that case was issued, and it was a victory for equality and a defeat for the claim that religion must have privileged status in American society. The court ruled that the University of California's Hastings College of the Law, out in San Francisco, was not required to give Christian Legal Society an exemption from the law school's non-discrimination policy for student groups. Just briefly, the CLS chapter at Hastings sought the law school's official recognition, a status that would have entitled CLS to student fee funding and some other perks. Among the law school's conditions for official recognition was that a student group seeking it agree to abide by the law school's non-discrimination policy, a policy that prohibits discrimination on the basis of, among other things, religion and sexual orientation. CLS refused to abide by the non-discrimination policy. Its membership rules excluded gay and lesbian students, at least the, quote, non-repentant ones, as well as students who did not subscribe to certain religious beliefs. Because the group refused to abide by the non-discrimination policy, the law school denied it official recognition. Now, the CLS chapter at Hastings could have continued to exist and have its membership rules as they were. The law school merely wouldn't subsidize it. CLS sued, claiming that the law school had violated the First Amendment. Ruling in favor of the law school, the Supreme Court said that rather than seeking to be treated equally, Christian Legal Society was seeking preferential treatment, special rights to which it had no constitutional right. Justice Ruth Bader Ginsburg, writing for the court's majority, said, quote, CLS seeks not parity with other organizations, but a preferential exemption from Hastings policy. The First Amendment shields CLS from state prohibition of the organization's expressive activity, however exclusionary that activity may be. But CLS enjoys no constitutional right to state subvention of its selectivity. Subvention is just a $10 word for subsidy or financial support. In the majority opinion, Justice Ginsburg makes masterful use of some of the conservative justices' previous rulings to support the decision against CLS, including, without limitation, the decision written by Justice Antonin Scalia in Employment Division v. Smith. In doing so, Justice Ginsburg and her colleagues in the majority placed Christian Legal Society v. Martinez squarely in the line of cases that stand for the proposition that the Constitution does not guarantee religious organizations exemptions from neutral laws of general applicability. In other words, religion is not above the law. I've put a link to the court's decision in the description box below. I think it's the best decision of the court's 2009-2010 term. A great victory for equality and a defeat for the notion that religion has a right to a preferred status. Well done, Supreme Court. Thanks a lot.